right, everybody. Justice is a process here. We have some breaking news in the Tyrone Tucker case. Today, a motion was filed by Tyrone Tucker asking the court to modify his pretrial release conditions, and this is in anticipation of a motion that he'll be filing in the near future to ask that the charges be dismissed. So we're going to go through that motion. It just made it to the Monroe County Clerk's office. We're going to go over it. We're going to read it. I'll give you my thoughts on it, on what this means. This is the first step. This will give a very good indication as to where this judge stands as this hits his bench. I don't know that it will be resolved on the 11th. He also filed, for anyone wondering, Tyrone Tucker also filed, which we're not going to review that. It's pretty much a pro forma motion. It's just something that's pretty normal. But he filed a motion requesting he appear via Zoom on March 11th for the status conference. So we'll see if the judge grants that or not. This will all be huge tells on how this judge handles this. And this new judge, as you know, is James W. Morgan. There's his background, former public defender. My recommendation would be, we've got to make our voices heard on how we feel this thing should go. So, but Judge Morgan will be the guy. Like I said, we were asking if it was going to be televised. It's not going to be televised, probably because it's a status conference. Although I think anything in this case should be televised at this point. But I believe at the status conference, they will set up potentially hearings to resolve the motion to dismiss, which will be coming as well. Obviously, the state hasn't had a chance. The state has, I believe, 30 days to respond to these motions. I don't believe that they would break from that. And they'll probably respond quicker than that, I would imagine. But we'll also see where the state's head's at. Is the state going to come back and try to continue to keep Mr. Tucker in the stringent conditions and keep him locked up like they have for the last 6 years? So, like I said, we're going to jump in here and read this. Let's pull it. I have it pulled up. So let's get into the details here of this motion. So here it is. Motion for modification of conditions of pretrial release comes now. Pro se defendant Franklin Tyrone Tucker moves this honorable court to grant the defendant's motion for modification of conditions of pretrial release, as the defendant's 6-year case history shows no indication he is a flight risk or danger to the public. This includes his voluntary appearance at trial, which concluded on January 25th, 2024, resulting in a mistrial. The defendant's conduct has shown that the original concerns for which the court ordered more restrictive conditions are now unwarranted and unnecessary. And again, I also hope we're going to go over. It's going to go over. I've already previewed this, but it's going to go over to give you an idea of the conditions Mr. Tucker is living under currently. So this is what they have put him under. So anyone who thinks he's free, anybody who thinks he's just walking around out on bond, couldn't be further from the truth, but it's going to be detailed in detail in this motion right here. So defendant's conduct was shown that the original concerns for which the court ordered more restrictive conditions are now unwarranted and unnecessary, that the need to ensure the primary goals of public safety and appearance should be satisfied. In other words, it's a mistrial. This is also going to force the state to have to come clean on, because one of the conditions that you set when bail gets set is they say that's why they had an Arthur hearing, and the state has to show that there's a likelihood of conviction. They don't have to show beyond a reasonable doubt, but they've got to still show that they've got strong evidence and they've got strong reason to believe that a conviction is going to happen. In this case, now that there was a mistrial, and they did this in the Y.W. Melly case as well, he has a right to file to get modified release. He's not locked up in jail. He's out on home confinement, but he's got the opportunity now to say, hey, we can relax some of this, because with this mistrial comes the likelihood that of conviction becomes lessened with the fact that they've already put him through one trial and they're not going to get another. The state, in their response, and we are going to be going deep into that when they respond, is going to have to come clean. Remember, state attorney's office, Dennis Ward, did a public announcement that the verdict was that the jury split was 11-1. Mr. Tucker's defense team established that it was 8-4 or 9-3, but it was not 11-1. Both of them were slanted towards guilty in both tellings, but 8-4, 9-3 is a lot different than 11-1, one away. And some of the things that were discussed that the jurors focused on, and I've got some content coming out here this week that I think is going to absolutely address a lot of the concerns that a lot of you have had, a lot of people have expressed in my comments. We're going to address it all. It's going to come out, and when we get to the end of everything that I'm going to present to you, you won't have any more doubts about Mr. Tucker's innocence, and it will give you less hesitation to support him and say, hey, listen, we need to get this resolved for Mr. Tucker right now. And his first step here is grant this pretrial modification. Now, anyways, let's get back to reading. Furthermore, the defense will allege that the state has acted unethically throughout the entirety of this case, including at trial. And we saw that firsthand, okay? I detailed a lot of the unethical behavior in shorts, the judge restricting, and it's a lot to get into, but I'm sure they're going to he'll be detailing this for the public to see, for the new judge to see. These allegations will be more properly addressed in a forthcoming motion to dismiss the indictment and information. But for the purposes of this motion, we would assert that despite its unethical tactics, the state still failed to prove the charges beyond a reasonable doubt. As such, the defendant would submit that the nature of the charges should no longer carry the same weight when considering the requested changes in the conditions of pretrial release. That any but the most basic conditions only serve to hinder the defendant's ability to act as counsel for his defense and act as a distraction from the actual issues in litigation. Therefore, the defendant would request that the current pretrial release conditions be modified to the terms the defense has included in its motion or to any terms that the court deems reasonable and just upon review. As grounds for granting this motion to modify conditions of pretrial release, the defense will offer the following. So we're going to go through the basis now for why they believe this pretrial release should happen and why the judge should grant it. So let's go through here. First supporting fact. The defendant was charged by indictment and information with felony murder and other felony offenses stemming from a robbery that occurred on November 17, 2017 at 5650 Laurel Avenue on Stock Island, Florida. The crime has become locally and internationally known as the treehouse unaliving. Let's see here. And that is contained, and again, I have the exhibits as well, which we'll run through here in a little bit, but there's exhibits A and B, which gets into that, establishes that. Fact 2, the crime occurred in Monroe County, Florida, with the presiding court having jurisdiction over dependency of this case. Fact 3, the defendant pled not guilty to all charges and voluntarily appeared for all hearings required, including the trial, which began on January 11, 2024, and continued to appear at all dates until the decision by jury resulted in a mistrial ordered by the Honorable Mark H. Jones on January 25th, 2024. Exhibit C, which I believe is the minutes of the trial, showing he appeared every single day without any issue. Fact 4, the state was unable to convict the defendant beyond a reasonable doubt for the charges currently in litigation, and based on a lack of evidence presented at trial, there is no reasonable expectation that they will ever be able to convict the defendant of these charges, thus making any pretrial conditions unwarranted. Exhibit C. In addition to the state's lack of evidence, the nature of the allegations for which the defense does have evidence and intends to present in a forthcoming motion are such that there is no reasonable expectation by the defense that the court, as prescribed by law, will fail to dismiss this case with prejudice, also making any pretrial conditions unwarranted. So that fact here, the defense, or he and his team are saying that this upcoming motion, which is going to be a big, big deal that's coming forth for a motion to dismiss, will be containing evidence that is going to essentially destroy the state's case to a degree that it's going to show that it's not even fit for presentation to a jury, that doesn't even meet the basics that a case would need to rise to be presented to a jury. So that's going to be huge. We look very forward to seeing that when that comes forward and analyzing that. There exists no reasonable expectation by any party that the defendant will abscond or fail to appear at any required hearing or at another trial if necessary. Fact 7, the defendant was incarcerated in the Monroe County Jail from November 22nd, 2017 to November 6, 2019, then released by agreed order with the state that required him to post a $2 million bond. Fact 8, the conditions of pretrial release were modified a few times in rapid succession due to the defendant's separation with his wife, but ultimately resulted in his relocation to his current residence and included a few new terms, Exhibits E and F, which are the terms of the orders modifying his previous release. The defendant was required to post an additional but significantly reduced bond. So this, everybody, we're clear this up right now. He's not out on $2 million bond any longer. They reduced the bond. It was in 2022. Okay, prior to when they knew all this stuff was coming out and Judge Jones was aware of everything, Judge Jones made a huge admission there when they reduced the bond from $2 million to $75,000, believing that the case was so weak. Now, remember, at that point, Mr. Tucker had attorneys involved. This judge was anticipating that if a trial occurred, it was going to involve attorneys. And at this point, he also knew that at trial, he was no longer going to be able to hide behind the gag order, which was still in effect in 2022. So he lowered the bond to $75,000 in hopes that this would potentially encourage Mr. Tucker to take a plea. Now, remember, part of what this state wants to do right now, part of the reason why that they've kept these strict, and you're going to hear about the strict conditions that they have, which go above and beyond normal conditions of bond, are in effect because they want to be able, and they've wanted to be able to keep the pressure on Mr. Tucker to plead guilty. Because as you're going to find when I present to you some of the findings and some of the pleadings and some of the things that have been going on in this case, which are all in the court record, just waiting for someone to find and read, you're going to find that they desperately have wanted to keep the things that they sealed that are currently under seal. There are things that are currently under seal due to the gag order that was imposed, that the seal is still in effect, because the gag order wasn't just about keeping Mr. Tucker silent. It was also about keeping the discovery from making it to the public domain at a time when they knew depositions and evidence was going to be going into discovery, which remains sealed, which Mr. Tucker can't put out and will only become unsealed when the trial is resolved. And potentially they could still keep it under seal if he would have taken a plea bargain. But if he's acquitted, there's a greater shot that they're going to be able to lift the seal on some of these things, which will be things like Penny Phelps's testimony, things like Penny Phelps's notes, things like various different pieces of evidence that have remained under seal now all the way through that Judge Jones was responsible for sealing. Anyways. So Judge Jones lowered the bond to $75,000. The defendant was required to post, this is fact 9, the defendant was required to post an additional but significantly reduced bond of $75,000 after the original bond expired. The new bond was lowered and ordered because the court no longer considered the defendant a possible flight risk, but due to the severity of the charges, felt that the monetary security was still necessary. The new bond was posted on December 22nd, 2022. Fact 10, during the entire litigation of this case, the defendant has not committed any infraction of the law and has shown no indication that he represents any danger to the public. Fact 11, under the current conditions, now this is where we're going to get into the conditions that he's currently living under, so pay close attention here. Under the current conditions, the defendant is required to remain at his residence in Clackamas, Oregon, where he may only leave for the following reasons: employment, religious service, legal appointments, and medical care. This condition has precluded him from daily life activities. He is not allowed to shop for groceries or other life necessities. He can't walk or take his dog to veterinarian services. He can't go to the post office to get his mail or other government offices, or assist his wife with family obligations, among other things. Remember, they have 4 children from her previous marriage, but 4 children that he could be very much involved with helping. He's unable to do those things due to the conditions of his release. Additionally, this requirement is significantly added to the cost of litigation by requiring that all life necessities, such as groceries, clothing, personal care items, be delivered to the defendant's residence at a higher cost. To eliminate the additional cost and allow the defendant more self-reliance, the defendant would request that this requirement be modified as indicated under suggested conditions. So at least let the guy go to the store, right? I mean, that's what these prosecutors have done. They don't even let, he can't, for them, as far as they're concerned, either afford the hugely highly cost of having things delivered and brought in, or have someone there who's going to be able to go shopping for you, know your size, go out. He can't pick out clothes. So for all of you making fun of his suits and doesn't he have more suits? He's not allowed to go shopping. When was he ever going to go buy additional suits? When was he going to do it? And he couldn't do it because the state didn't allow him. So, before you are out here talking about these things, I'm not saying any of my viewers were ones out there talking, but these were comments that were made during the trial, which people didn't understand what they were seeing because they heard, oh, his wife's a millionaire. Well, his wife might be a millionaire, but he ain't able to enjoy a bit of it. He's not able to even go out and buy his own clothes. He has to buy clothes that he has to guess at whether they fit. They got to get brought over to his house. I mean, this is what they've got him living under for the last 6 years. And the thing is, he's an innocent man. And I'm telling you, he is an innocent man. He did not do this. And the evidence didn't show that. And the state now makes a decision to retry him moments after a mistrial, showing once again the bad faith that this prosecution has come under. Fact 12, the defendant has been required to wear an ankle monitor throughout the entirety of his pretrial release. The main purpose of this device, besides ensuring he stay in authorized locations, is to act as a deterrent to absconding or avoiding appearance before this court. This condition also adds to the cost of litigation at an approximate total of $6,720 to date. He's had to pay $6,720, and if he doesn't pay that, ladies and gentlemen, he gets put back in jail. So luckily, he does have resources to make these payments. But if someone doesn't, and this is what they're doing to him. So again, what would be the pressure? What would someone do if they didn't have the resources to pay these type of costs? They would take a plea. They would take a plea and not fight them. So even though they released him on bond, they say, well, if you want to get back to jail, don't pay this bill. But if you don't pay, if you don't pay the bill, you're going to jail. So then they say, well, we have a way out. Time served, take a plea, and kick this thing under the rug. And part of the plea bargain says, because you took responsibility for this, you're never going to be able to sue anybody. You're never going to be able to bring attention to this. The public's going to look at you like you're just a criminal who got away with a sweet deal. And no one will ever bat an eye or ask a question or look down there to see what really happened in this case. Additionally, it offers the state the ability to request the defendant be returned to pretrial detention simply because of a malfunction, damage, or human error causes the unit to stop working or provides a false location. So imagine how Tyrone Tucker has to be feeling right now, right? I mean, imagine how you would feel if you knew you have the state of Florida, who you know is prosecuting you for a crime you didn't commit. You've watched them do untoward number of things that were unethical, that were dishonest, and you know all it takes is them to file a motion to try to get you thrown in jail because they say, well, we got a bad location. It stopped working. Oh, there was an error. And there's nothing that stops them from doing that. There's nothing that stops them from doing that right now, except for them to know and us to know and make sure everyone knows we are watching. And there's nothing more important that you can do for Mr. Tucker right now if you have come to the conclusion or eventually do come to the conclusion that this is an injustice, make sure they know we're watching. So they know that they only come to court with facts, that they're not going to get away with what they've gotten away with for 6 straight years with messing with this guy and trying to do everything they can to try to railroad this guy, either by getting him to take a plea that is not true, or by trying to lock him up for the rest of his life, which is what they wanted to do and what they would have had their way doing last month. The unit also requires that the defendant take 2 hours out of every day to charge, during which very little can be achieved. So imagine this, whether you know this or not, 2 hours a day. Imagine if you had to sit at the wall, plugged into the wall. Mr. Tucker is like a robot. He has to plug himself into a wall like a computer, and he can't leave that area because if his ankle monitor goes off, he can't go to sleep until it's plugged in. This is his life. He's chained to a wall. He's got a electronic chain on his leg, and he's got to plug that in every single day for 2 hours a day. If he doesn't do that, state of Florida is going to send him back to jail. I mean, that's how this works. This has presented problems in the past with scheduling other required activities associated with release or in conducting the defense. With the additional cost, the additional risk, and the hindrances to the defendant, in the absence of any reason to believe the defendant will fail to appear, the defense would again request that his conditions be modified as indicated in the suggested conditions. Fact 13. Currently, the defendant is under the condition that he refrain from use of alcohol, requiring that he present himself for random urinalysis at his expense. Where do you see the cost of this? A month, okay? And if he doesn't do this, he goes back to jail. So imagine if he's a man of limited resources and he had to pay these costs. He has no choice but to not pay them, and he goes back to jail. That's what's going. Like, understand the connections here of what the state of Florida has done to him and what they're doing to him actively. This condition requires the defendant to avoid contact, or use of a wide range of common products, including but not limited to mouthwash, antiseptics, cooking ingredients, certain foods, medications, cleaning supplies, hygiene products, energy drinks, non-alcoholic beverages, and others. He has to avoid all of these things because there are enzymes and there are chemicals in these that could give a false positive. In addition to the large number of products containing alcohol, the defense has researched the current testing methods and found the accuracy of these test results is only 70%. False results could be either positive or negative, but this seems extraordinarily high to be a condition which could potentially require the defendant to return to pretrial detention. The defense views this as just another distraction from the actual charges and litigation and another unnecessary cost, as current testing is approximately $320 a month. I want you to understand that. He has to pay $320 a month for these tests out of his pocket in order to stay out. They have him paying, of course, costs associated with the electronic monitoring. They have him paying costs associated with testing that they want him to do. And the defendant has, and this test is only 70% accurate. Can you imagine the stress that he's under? Wondering, is today the day they're going to come back and say, oh, there's a positive. In fact, if you go back in the record, right before trial, they tried to come back and say he had a false positive, and the court ended up, Judge Jones didn't end up pursuing it because of the lack of accuracy of this test. The defendant has no history of violent behavior or crimes relating to alcohol and poses no threat to the public. Exactly. Why alcohol? Drug testing? Okay, I understand that. You shouldn't be using illegal drugs, but alcohol is legal. He has no documented alcohol problem. He's not charged with DUI. He's not charged with anything related to alcohol. Why is alcohol part of it? Why? He can't even have a beer to watch the Super Bowl, And this has been in effect for 6 years. 6 years. Therefore, with the potential risks of false results and incarceration, the added distraction and added cost, the defense will request that this condition also be modified as indicated in the included suggestions. Fact 14. The defense is requesting these pretrial conditions of release in good faith, with only the most restrictive conditions modified to allow the defendant greater self-reliance, reduce the already exorbitant costs associated with litigation, reduce distraction from the actual cause and risks to the defendant, allow the defendant the ability to be more effective in his defense, and afford the defendant more freedoms for which his displayed conduct over 6 years and the recent result at trial should warrant. Suggested pretrial release. So this is what he's suggesting should be put in place of what's already there. And you tell me if you think this is unreasonable, right? And let's go over it. Condition 1, that defendant remain at liberty to the $75,000 bond posted as collateral to ensure appearance in court. 2, that the defendant's wife, Lauren Janai, remain the surety for the bond in emergency contact if pretrial services is unable to contact the defendant immediately and requires a response in less than 24 hours. Mrs. Janai will also contact pretrial services and inform them if the defendant is injured, deceased, or any other circumstance that would prevent him from communicating. 3, that the defendant continues to reside at blank Avenue, Clackamas, Oregon, so long as there is no legal prohibition against it, with the defendant notifying pretrial services if and when his residences become subject to any changes. Any changes in residence must be approved by the court prior to the actual change taking place. 4, the defendant be allowed to leave his residence unrestricted so long as he does not leave the state of Oregon unless otherwise ordered by the court or approved pretrial services. 5, all travel outside of the state of Oregon be submitted in writing to pretrial services and is subject to approval by the court. 6, defendant be released from electronic monitoring but continue with weekly checks already required. That the defendant also be subject to random checks via phone or email, and that failure to reply to pretrial services within 24 hours will constitute a failure to comply unless he can show extreme circumstances preventing him from contact. Additionally, any violation of the conditions of contact, movement, or appearance included herein without extreme circumstances be considered a failure to comply that would, upon order of the court, subject the defendant to being again monitored electronically unless the violation is considered so severe as to return him to pretrial detention. The defendant continues to abide by 7. The defendant continues to abide by all laws applicable to his location, reporting any contact with law enforcement to pretrial services. If the defendant is found to have violated the law and alcohol use is found to be an underlying factor in the crime committed, this factor will weigh heavily in any decision the court makes concerning his possible return to pretrial detention. 8, that the defendant no longer be required to take random urinalysis with the understanding of the condition above and the weight with which the court will consider any crime that alcohol has as its underlying factor. And 9, any other terms which were not addressed in this motion would remain in effect until further order of the court. Certificate of service. I hereby certify that a true correct copy of the above and foregoing was furnished via e-service to attorneys of record in this case. You've got pro se Mr. Tucker, and then you've got Mr. Higgins, Mr. Bellarito, Mr. Alvarez, Mr. Mansfield, and then the state attorney's office and pretrial services. So, look, this motion, okay, is, in my opinion, something that should be granted. And I think that we all have the ability to make our voices known on this. We need to let the authorities know down there that, hey, we want this motion granted. This motion is something that the public does not feel he is a threat. So if you feel that way, you determine how you think you should make your opinion known. But make your opinion known, put it in the comments, comment so that he knows. Go to his Facebook page, put a little comment in there that you support this motion, because it's important. Because one of the factors that the state's going to try to rely on in here is to say that he's a threat to the public, that if he comes off of this very, very strict home confinement conditions, that they believe he's going to go out and commit another crime. Clearly, I don't think that's the case. He is very focused, obviously, on his defense. He's focused on getting this pretrial motion to dismiss, the motion to reconsider, the motion to dismiss. He's got new things to add to that. That's where his focus is going to be. And he shouldn't be having to worry about, are they going to come violate me because there's a malfunction with my ankle monitor, or the 70% accurate alcohol test comes back and pops him for mouthwash. He can't even drink a Red Bull, for Christ's sake. I mean, can you imagine that? He can't even drink, so the idea that he's free, he isn't free. He can't leave to go get dressed. He runs out of underwear. He's got to either call a delivery service or he's got to call his wife. But even if he was working, he couldn't make a stop off at the store. He's under GPS monitoring. So everything he does is monitored right now. He's a prisoner in his own home, and he's got to make sure for 2 hours a day, he's got to lock himself down to the charging cord, like he's a human laptop computer, where he's got to charge himself up, because if he leaves to go somewhere for an appointment, if he falls asleep and his monitor or his ankle monitor turns off, he's going back to prison. He's going back to prison. Not to mention that and previously there was a previous motion, as you're seeing here. Let's go into the exhibits here. Give me a moment. I've got to drop that in, but you're going to see some interesting information of how things were. But there was an incident where he had to actually go and fly. They ordered him to fly back at his own expense because they needed to do some repairs to his ankle monitor. And if he didn't do that, they were going to come pick him up and bring him back in handcuffs. I mean, it's insane. So let's go here. I got to bring this over and drop it in. There we go. All right. All right. So here are the exhibits. Let me make sure this thing is okay. Good. So it's there. All right. So here's the exhibits. We've got the grand jury indictment. This was Exhibit A, and this just gets into the things we already know. This was the amended information that was filed later on. Then this lays out here the different things that's all attached to the information. Now, this is the minutes of the trial. So this just shows he showed up, right? So that shows he showed up to court and goes into all the different things. It's actually quite interesting. You can go right on to Monroe County Court. You can find this document in a separate document, or you can find it as part of his exhibits for this motion. But we're going to get to the motion that's to what's interesting here. This was an order from November 2019. So this was the original order for his bond, that he had to pay $2 million bond, $1.5 million for the charge of first degree unaliving, $100,000 apiece for the other charges. He has to report to pretrial services once a week. He can't consume alcohol. He doesn't have a passport, but he would have had to agree to turn it over, and he can't seek one. The defendant is electronically monitored at the defendant's expense. In any event the Elmo unit requires service, he's permitted to have the Elmo unit service remotely by an entity approved by pretrial services. In the event that unit requires service prior to the defendant securing a pretrial service approved entity to service, no such entity exists within 24 hours of notification of pretrial service. The defendant is required to provide proof of purchase of a plane ticket, okay, to travel to South Florida that schedules the defendant's arrival in South Florida within 6 days of the ticket purchase. Thus, the defendant must be back in Monroe County no later than the 7th day that he is notified of the service of his Elmo unit is required. So, should the defendant obtain employment, says the defendant shall not change residences without prior approval. Should the defendant obtain employment, defendant may be outside his residence for work purposes. Defendant is also permitted to leave his residence for medical, legal, and or religious, but he can't go shopping. He can't get groceries. He can't eat. He's got to be solely reliant on another person for that. All contact information's got to be handed over to the clerk of court, and obviously no contact with witnesses. So then in 2021, they do an amending here. Defendant Tucker may reside, that gives him the new address. Defendant is subject now to random urinalysis for the presence of alcohol, not drugs, alcohol. Think about this. Not drugs, alcohol. The question is why? Why couldn't he drink alcohol? What basis does alcohol have in any of this? This isn't a charge that he got drunk and did something. So why? I mean, to me, that's just insane. The defendant shall not possess any weapons. The other terms in the agreed order setting bond or other terms dated remain in effect. The court acknowledges. Now this is the interesting part that I want you to hear here of how this monitor creates issues for him. The court acknowledges pretrial services concerns regarding the lifespan and the condition of the electronic monitoring device defendant is currently wearing. The court finds that defendant Tucker has not caused any damage to the device. Todd Lambertus of pretrial services will attempt to find a vendor who can repair or replace the existing electronic monitoring device in or around Portland. In the event that Mr. Lambertus cannot locate a vendor, he will direct the defendant to fly to a location in South Florida to replace or repair the device. The court will rely on pretrial services determination and instructions to the defendant, and no further order from this court is necessary as to this issue unless specifically requested by the parties. Mr. Lambertus shall advise the court, the state, and counsel for Mr. Tucker as to instructions to the defendant. So, I mean, think about that for a minute. I mean, he can be ordered to fly back at any moment. That's where they're at for this electronic monitoring device. What's the necessary need for it? He's clearly not any danger to society at this point. He's gone through one trial where the evidence was so weak. He represented himself pro se, and the jury was unable to come to a agreement. So now we had another agreed order modifying the terms of release. This cause having come before the court by agreement between Jerome Bellarito, that was his old attorney, on behalf of the state of Florida, Todd Lambert, is in the court having heard the comments of counsel. Defendant Tucker, they said he could reside, agreed to his conditions about not leaving. And now I want you to understand this. This unit is located in Crown Court Apartments. He lives in an apartment complex. Okay. The defendant is permitted to use the curtilage of his apartment building in his designated parking lot. In the event the defendant needs to access another building in the complex, he shall request approval from pre-trial services as he would for any other medical. So I want you to understand this. And Mr. Tucker's mailbox is located in another building. They did this on purpose. So when he goes to get his mail, he's required to call pre-trial services and get approval to walk to that building to get his mail. That's what they've done here. Can anyone please explain to me why that is something that would be necessary? The remainder of the terms in the agreed order and other terms of the defendant's pre-trial release dated November 6, 2019 apply. And then saying everything else and the other modifying terms from June also apply. So I'm like, that's what we're living. So anybody out there that's thinking, oh, Tyrone Tucker, man, he's living the life. He's got himself a millionaire's wife and all this. No, he's been incarcerated in his home for 6 years. He's been in Monroe County Jail, or detention center, for 2 of those 6, and then for the last 4.5, he's been incarcerated in his home. He can't even walk to go get his mail. He has to have either someone else grab it for him, or he's got to call pretrial detention and say, hey, do you think it's okay if I need to get approval to walk? And then they give him a set time frame, and then he's off to the races, and he's got to run over there to make sure he's back with enough time to make sure that they don't come and bust him. And what do you think right now after the trial he put on? Do you think when you judge Mansfield and Alvarez and how they acted in that courtroom, do you think they're not chomping at the bit at an opportunity to try to throw him back in? Do you think if they thought, if we weren't watching right now, if there wasn't people looking, if Court TV wasn't monitoring this case, do you think they wouldn't jump at the opportunity to put Mr. Tucker back behind bars and throw away the key? Absolutely they would. Absolutely they would. And that's why it's important we watch. It's also important that with understanding that what's at stake here in this motion, that we make it known, you make it known if you can, any way you can, that you make it known that you believe that this motion should be granted. And do it through comment sections, put comments on Facebook, make the voice known, make it known so that Mr. Tucker has your opinion on what should be done, and he can use that. Because they will listen. The state attorney's office pays attention to Facebook. They pay attention to YouTube. And I'm going to show all of that to you because they showed they did, because as part of the gag order that they put in effect, which shut down the ability for the press, because there was a time 4 years ago that the Washington Post, the New York Times, every major news organization was looking at this case and was asking questions. And what they did was they shut that down. They sealed all the evidence. They stopped Mr. Tucker from being able to speak, and they essentially allowed this thing to drag on for 6 years. And then they hoped that Mr. Tucker, under these horrifying conditions of release, not even able to leave to go get his own mail, not even able to clothe himself, not even able to feed himself without assistance, to take away all his freedoms that any of us would enjoy, says, okay, charging him $320 a month. They figured they would break him, and they'd get him to take a plea, and they get him to do what they wanted and agree to what he wanted and make this go away. And he said no. Not only did he say no, but he took him to trial. He took him to trial completely unprepared because they tricked him in the trial. and they tricked him in the trial because they made him believe that JoJo or John Johnson or John Travis Johnson, that he wasn't going to be available, that he was in the wind, that he had gone out and relapsed, and he thought he was going to show up in January, and they were going to start the trial, and they weren't going to have their star witness, and he was going to get a directed verdict of not guilty because they'd have no other option. But you know what? The state played with him, and the state tricked him, and guess what? John Travis Johnson, otherwise known as JoJo, wasn't in the wind. He was sitting right there, and they brought him in, and they went to trial, and that's why Mansfield sat in that courtroom and said, we have a unique opportunity, Judge. I don't want to mess up the record. I don't want to risk a mistrial. I don't want to risk doing anything that would stop this trial from going forward because we have an opportunity. We have an ill-prepared defendant. We have a defendant who hasn't secured subpoenas. We have the ability to keep Todd O'Quinn out of court. We have the ability to try to keep Paula out, which mysteriously she gets given Xanax. And remember, in the days leading up to her testimony, there was Mansfield was demanding that they have a investigator at their office at that hospital prior to her testifying. And I'm not suggesting, I don't have any evidence to suggest what happened, but I'm just telling you why. And then when they're having problems, when they're having transmission issues, Mr. Mansfield says, well, we don't want him going in there. She's sick. And they said, well, they can put on one of those suits. No. He stays out in the hallway. So what was he doing there? Why was he there? What were they doing? I would love to be able to figure out a way to talk to the people at that hospital. And if someone would go on record, if someone wants to talk, reach out to justiceisaprocess@gmail.com. We can talk. But I would love to know what was going on at that hospital that day that got her. Because now, guess what? Conveniently, she's passed away. Now the opportunity to ever get her on record, to ask her about things, to ask her about who JoJo was and what she heard, because she heard from friends that it was John Travis Johnson, which would have been a hearsay exception, of course, but it could have potentially been asked. Those questions could have been asked, and the jury could have at least heard that it existed. We could have asked her, you heard a car, right? Can you imagine the power of her saying, I heard a car start. I heard the white guy run down, get into a car start and drive off. We have Todd O'Quinn comes in and testifies, and he's presented, and his memory is refreshed from the fact that he said he saw a guy go down, get in a truck, and drive off. Corroboration. And then on top of that, it would have been allowed that the photo array would have been able to bring in and said, did you not identify John Travis Johnson, right? Otherwise known as JoJo. And then what is being said all over the island? What's being said that day by people is that John Travis Johnson was the individual that was responsible in this. Wouldn't that have been absolutely unbelievable evidence to the jury to show that this was not Mr. Tucker? And then on top of that, if they would have been able, if it would have been able to have been, clearly shown that the IA report demonstrated the fact that this investigation began because Penny Phelps decided that Tyrone Tucker was that individual, that they thought Tyrone Tucker was the individual in the Keys Electric video, and that because of that, because she thought it was Tyrone Tucker, and Danielle Malone thought it was Tyrone Tucker, and they thought all the evidence was pointing to Tyrone Tucker, that they then went to Rory Wilson, and they had Rory Wilson implicate Tyrone Tucker. They had Rory Wilson's girlfriend. She sits her in the car. We haven't watched that, but we're going to be watching that together when she sits April Walker in a car and convinces April Walker to say that she saw Tyrone Tucker taking clothes off at midnight, hours after this occurred. Nothing in relationship that could even be constituted. But the important part is what Ms. Phelps says to April Walker, where she says, before she realizes that the individual she saw walking on that Keys Electric video wasn't Tyrone, she says, I don't like Tyrone. I think he's a bad guy, and he did this. And you hear in the, which again, Mr. Tucker, you see in the minutes, if you review those minutes, when you go on the trial minutes, you hear talk about a interrogation room, and you go on his site, and we're going to listen to it together as well eventually. But you hear on there Penny Phelps talking about how they have to go after Tyrone, how they believe it was Tyrone, how they believe Tyrone is their guy, how they have to figure out Now, what their strategy has to be is to lean on Rory Wilson and lean on April Walker, because the only way they're going to identify the white guy was to get April Walker to to convince Rory to name Tyrone Tucker as that other individual. So what does she do? She goes in and she attempts, and you're going to watch as we go through the interrogation, she uses the same line about her grandmother over and over again. Two sides to every story. There's a thin line and the truth lies in the middle. She uses that on April. She uses that on Rory. She uses that on Tyrone. She uses that on John Travis Johnson, otherwise known as JoJo. She gets John, and she now is locked in. The moment that she pushes and she demonstrates her tactics, and Colleen Dunn is there with her. Colleen Dunn, who has used confidential informants over and over again in her cases, has had no problem prosecuting cases that she knows are weak, that she knows are based on paid confidential informant testimony, is right there consulting her. You hear her on the interrogation room tape talking about it, the same tape that you can hear Penny Phelps talking about trying to get the identification of Rory Wilson under. This is all going on. And then what happens? On the 22nd, Penny Phelps' entire belief in the case falls apart, because guess what happens? The Tom Thumb videos come in. The CVS parking lot video comes in, because we hear it in the interrogation room. They had tapes from CVS, the very tapes that you hear Todd O'Quinn talking about, the pitcher. That pitcher told them, we had the tapes from CVS. They come in, they get these tapes, and guess what? We don't know what, because we never hear about them again, because they get destroyed, mysteriously destroyed when a hard drive malfunctions. And then the Tom Thumb footage gets destroyed when the detective pitcher's phone mysteriously resets on its own, and it's all gone. And the only thing we're left is with the Cosme parking lot that shows Travis Johnson's truck pulling up, because all of a sudden now, Penny Phelps realizes she has a big ass problem, because when they get that footage, they realize it's not Tyrone Tucker on the tapes. It's John Travis Johnson, otherwise known as JoJo, which Paula tries to tell them. Todd O'Quinn tells the first officer ever. Todd O'Quinn is telling them that it's a white guy, 135 to 140 pounds, fitting the description. Suddenly, she's in a huge pickle. So what do? They set up John Travis Johnson to come down and talk to them, and they get her in the room, because she now knows what she has to do, because she knows this case is in big, big trouble, because she's just elicited Rory Wilson herself and April Walker. She has just got them to say a false statement against Tyrone Tucker, which now she needs Tyrone Tucker to be involved. So what does she do? She rolls John Travis Johnson straight in to the sheriff's office, and in he rolls. And for 6 minutes, she sits down with him and tells him the story she needs him to say. She lets him know, we know your truck was there. We have you on videotape. Not only that, but just before he gets in there, she already knew that Todd O'Quinn had pointed out John Travis Johnson as the other guy. So she pretty much lays it out to him. Either you're going to tell me what I want to hear, which is that it was Tyrone Tucker and you're the driver, and you're going to tell the story I'm going to tell you, and I'm going to show you the tapes, and you're going to learn this case, and you're going to do exactly as I say, because I need you to do it, because if not, it's my ass, I lose my job, and I get exposed for essentially using terrible interrogation and investigative tactics to get Rory Wilson to implicate an innocent man. I can't have that. It's me or him. It's a guy living at Cots. It's a homeless man. So what does she do? John Travis Johnson is fed for 6 minutes live on tape that's played for you right there. She feeds him the story. He tells her it's Tyrone. They arrest Tyrone. They lock him up, and Tyrone's nightmare begins. And she now, as you hear in the same interrogation room, she has a hot mic, and they're saying in there, God help us. We hope the DNA supports this, and we sure as hell hope that Todd O'Quinn comes around and says that Tyrone is the guy, which Todd O'Quinn never does. He stands steadfast and true that the individual he saw pull off his mask wasn't Tyrone. The problem is no one saw for years the tape where Todd O'Quinn not only said it wasn't Tyrone Tucker, says it looks like Travis Johnson, but he also has forgotten and locked away in his memory the idea that he saw that individual get in a truck and drive off. Paula, at her deposition, continues saying she heard a car. It's said in her deposition in 2019. It's said in her deposition in 2021. To use the words correctly of Mansfield, that's called corroboration. It's corroborated in all of those forms. That's what's going to get played at the next trial. Paula being corroborated that she heard a car start. Todd O'Quinn is going to remember and have his memory refreshed. I'm quite certain when he hears that, his memory is going to be refreshed to the fact that he did not just see an individual leaving. He saw them get in a truck and get out of there, just like he told Officer Blake or Detective Blake, whichever it was. I'm not sure if it's officer or detective, less than 2 hours after he leaves. And then never again is he asked about a truck. He's always asked about a car. Never again is he directly asked about anything about what he saw or how they got out of there. And Todd O'Quinn just goes on and never comes up again. And then what happens in December of 2019 or 2018, I believe it is I believe this is December of 2018. The DNA comes back. The DNA, the very DNA that Mansfield and Alvarez argued to the jury, proved somehow that Tyrone Tucker shouldn't have known what the results were. The problem is guess what? The only mask and the only knife, there was one mask and one knife that was stuffed in a boat, right? In a boat, like a boat storage, which the police find. The problem with that is that doesn't support that there were two people on foot that night. That supports that there was one person on foot. One person on foot who had to get rid of those items because they couldn't be seen out in public because police were flooding the area. People were looking and watching. And then there is one person who we don't find the mask for, but we know they were in a mask. They don't find the billy club or the knife or whatever it is they had in their hand, which we know they had. Why is that? Because that person drove off in a truck. That person had those items. That person was able to dispose of those items out of the sight of everyone else and all the cameras. No, remember, there are cameras. You've heard this if you've watched any of these interrogation videos, and if you watch the one of Tyrone Tucker, you hear Penny Phelps say, there's cameras everywhere. So where is Tyrone Tucker if there are cameras everywhere? Because the only cameras that has anyone on them during the time these crimes were committed is Rory Wilson and JoJo John Travis Johnson. Those are the only people ever seen on a camera. And John Travis Johnson, it makes perfect sense why he's seen on the camera doing the things he's doing. His truck is seen there. He runs away, gets in his truck, drives back, and then decides, I got to head back because my man Rory's out there. He parks his truck and he heads back. And you see him right on the video heading down Keys Electric. The problem is all the Tom Thumb videos don't exist. Why? Because they claim they got the wrong day. But the belief is they didn't get the wrong day. They just didn't like what they saw on them. Because the Tom Thumb video showed the truth. And it showed the truth at a time that Penny Phelps had already locked herself in to lies and had already locked herself into the typical bullshit that she pulled in all of her cases that she did because she had decided, I'm going to be the king, or the queen, I guess. I'm going to demonstrate to everybody. This is again, remember, Key West doesn't have a lot of unalivings. So what happens? She gets excited. She's going to show off what a skilled police officer she is. And what does she do? She takes over the investigation. How do we know this? Because she's right there questioning John Travis Johnson less than an hour after this happens, right standing in front of the truck that ends up being in the video. And there she is, not any other officer in the scene, but Penny freaking Phelps, the captain, telling him, have a good night. Thank you, John. And if you need anything, let me know. And if you remember anything, let me know. Do you know what egg on your face that looks like when you think you're the superstar investigator and you had your guy sitting right there? You have Officer Pacifico. Officer Pacifico tries to tell the sergeant, and he says, I know Roy Wilson lives here. And he gets John Travis Johnson right in front of Phelps to say, yes. And he says it. Bingo, there you go. Officer Blake's over on the phone saying that he's got a damn, he's got helter-skelter here. He's got a shit show going on. And Officer Pacifico, and Phelps is standing right there. And he says, yeah, you're right. Rory Wilson does live downstairs. Even after he said, now they claim that he said everybody was gone, but he admits, he says, yeah, he's there. I don't know if he's there or not. And Pacifico says exactly right. He starts saying, Sarge, we got to get someone in. We got to get someone in. We got to get a search warrant for this place. You've got Rory Detroit Wilson lives in the bottom apartments. You've got a white guy standing right there. You've got, if they get a hold of Tyrone Quinn, and if they listened to Tyrone Quinn, they would have known in less than 2 hours that Tyrone Quinn said he saw the white guy jump in a truck and leave. They know this guy's standing in front of the warehouse apartments where Detroit lives. They have their case, but they didn't pay attention. And Phelps didn't pay attention. And when Phelps looks back at this and realizes all of this, can she go forward and say, oh my God, I made a mistake? No, because what does she do? She proceeds forward. They think there's a shrimper. They clear the place. She clears the place. And she has a big problem. And the big problem is she had her guys sitting right there. And she did nothing. She showed her utmost incompetence. She showed exactly why she should have not been investigating this case, and she should have brought in higher authorities. But somebody like Miss Phelps wasn't going to do that because she had a big ego and she had a big desire to be the king or the queen. And she leaves the scene and she goes back, and the next day or a couple days later, she finds out that Roy Wilson is with a white guy at Metro T-Mobile, whom she identifies as Tyrone, whom she says actively, right to April Walker, I took a look at this guy and I don't like the way he looks. I took a look at this guy and I don't like the way he looks. He looks like a killer. He looks like the type of guy that would do this. He looks like a bad guy. And she says some of the most hideous, terrible things about him. And the sole purpose isn't because she believes any of it. It was because she was trying to get April Walker and Rory Wilson to turn on Ty Tucker, because she believed at that moment that Ty Tucker was her guy. And she believed that the video was going to confirm it, the DNA was going to confirm it, and eventually Todd O'Quinn was going to confirm it. And all the way up until the moment that it didn't, she pushed forward. But the problem is she pushed forward a little too far. She reached in and she got a false confession out of Rory Wilson, and she got April Walker to say falsely that she saw Tyrone Tucker changing clothes. And once she did that, she herself could not walk that back, because it's either she has to admit she elicited a false confession. How else do you explain Rory Wilson saying what he said? Or Tyrone Tucker's involved. So she goes with the latter. It's her ass or his ass. And she didn't care. She wasn't going to lose her career, and she wasn't going to lose her freedom off of somebody that she thought was a homeless guy living in cots. So she proceeded forward, and she said, all right, that's fine. We will elongate our theory, and we will just add a third person that wasn't there. A third person that never shows up on a video, that never shows up in a witness statement, that's never discussed, that no one ever talks about. The only person that ever talks about a third person being involved is JoJo, the guy it was in the video who was there, who said, and I believe him when he says this part, I never thought it was going to be what it was. I never intended to be involved in something like this. And I believe that emotion and those tears were real, because he realized he had ruined his life. And at that moment, he thought he was going away for prison for the rest of his life. And he has found himself the sweetest deal a guy could ever find, given the circumstances that he found himself in, because Penny Phelps screwed up. And everyone has asked the question, why would Penny Phelps go after Tyrone? Why, oh, why, oh, why, oh, why? And the reason why is because Penny Phelps got a false confession out of Rory Wilson when she thought the evidence was going to prove that Tyrone Tucker was the other guy. She was an incompetent, foolish detective who made assumptions. And as a result, she ended up being stuck with her theory. And she ended up literally faced with the decision, either I have to admit that I elicited a false confession out of Rory Wilson and got his girlfriend, wife, soon to be wife, to lie, and I'm going to have a lot of scrutiny coming down on me on how I acted up until this all comes out, because she knew this wasn't going to go away, that the only way she could continue forward with this case and have a chance of closing this case without this whole thing blowing up on her was to implicate Tyrone Tucker. And that's why, but the problem is, she figured, and then, again, as this progresses, she figured, and Colleen Dunn assured her, and they go use a common tactic that Colleen Dunn had used to close cases. They Immediately, within a couple of months of him being locked up at the Monroe County Detention Center, they get a paid confidential informant who'd been used over 40 times by the Monroe County Sheriff's Office. They move him into the same cell area as Tyrone Tucker, and he gives the world's most ridiculous statement about the case that has no bearing or relevance to the evidence in the case. Really, truly doesn't. The only thing that has any relevance is he says Tyrone Tucker says he was involved in this thing. Everything else he gets wrong. But they didn't care. They take that to his Arthur hearing and use it to keep him incarcerated. Because what they were trying to do in this case, and what they would have done in this case, if he would have been allowed to remain locked up, is if he would not have been able to have found an old childhood friend who ends up turning into his wife down the road, if she wouldn't have come in and helped, if she didn't have the resources to help, they were anticipating that eventually he'd get tired of being in jail. They'd come to him. They would get him to say whatever they wanted against John Travis Johnson and against Rory Wilson. This is their thought. This is their out. And then he's going to testify against them, and they'll give him the sweetheart deal, and they would be okay with doing that because now they would get Tyrone Tucker to be the witness they need against John Travis Johnson and Rory Wilson. That's why they didn't make the deal right away with John Travis Johnson. That's why they didn't make the deal with Rory Wilson, because they figured this is a group of homeless crackheads who have no allegiance to each other, and that they would break him like they have everyone else, and Tyrone Tucker would play ball because he was facing life, and he's sitting in the Monroe County Detention Center. But guess what? That's not what happened, because Lauren Janai came in and messed up their plans and provided Ty with the resources so he didn't have to do this. And now Tyrone is talking about it. And now Tyrone is coming for them. Tyrone goes and gets people interested in it. In 2019, if the gag order would have never been entered, the Washington Post and the New York Times and all these people would have come in and they would have seen this for what it was. And they would have been covering it when Detective Pitcher's testimony would have come out, when Penny Phelps' testimony with deposition would have hit. And everyone would have been able to see it. And it didn't go under seal immediately because of the gag order requiring everything that entered the discovery process or was filed went on an automatic 90-day seal with the option for Judge Jones to be able to extend that seal or release it, all predicated upon whether either the state or the defense requested that seal continue, which, of course, what does the state do? Almost every incriminating piece of evidence to the state, almost every exculpatory thing that could have made Tyrone Tucker look innocent, they sealed. And that is in the record. Go to Monroe County Clerk of Court and look it up. And I'm going to show it to you in subsequent videos. That is exactly what they did every single time. And they hid this. And then they went in, and when you realize what they did in the scheme they used and how Judge Jones was at the top of this scheme, because in order for him to seal it, he had to do an in-camera review of every single one of those documents. And which means Judge Jones was aware of the contents of every single one of those documents, which means any document that would have shown Tyrone Tucker's innocence, and there is plenty, I am certain, that would have shown the unethicalness of the investigation, would have shown Phelps doing what she was doing, trying to cover this thing up. He was aware of. The reason why he got out of this case, which if you go back and play, in fact, I might play it here as an ending here, but you go back and you watch Court TV's coverage and you watch the coverage of the motion they just did. They just covered the fact that this judge recused himself. They state in that broadcast, this is an unusual situation. It's unheard of that a judge would end up recusing himself from a case that he has already set for pretrial and gives no reason for it. Not a reason why they would do that. And, but they give him the benefit. They say, well, we're not going to assume this judge is doing anything bad. We assume he has a set of facts that he's aware of. I'll tell you what those set of facts are. Is this judge knows the gig is up. This judge knows people are watching, and this judge knows what is about to happen because of the fact that Tyrone Tucker gets another shot at this. And he knows that Tyrone Tucker isn't coming to town next time unprepared. Is he coming to town having to service subpoenas on a whim? Is he coming to town thinking that JoJo John Travis Johnson isn't going to be there? No. He's coming to town for the next trial, guns loaded, ready to go, and ready to knock this case out of court. And he knows there's going to be another motion to dismiss. He knows he's going to get called out. He knows the gag order was already being questioned. He knows that he illegally gagged Tyrone Tucker's wife, a non-party to this case. He gagged her because of the website that I can attest personally is extremely helpful in understanding this case, and that is the Free Tyrone Tucker YouTube site. And there used to be a website, but she had to take it down because in 2019 they gagged her and they said she had to take it down. They gagged her for the express purpose of not wanting her to talk. And then what they did, and again, there's motions to back up all of this, then using that same gag order, they attempted to hold her in criminal contempt as well as Tyrone because she spoke, or a news article. It was, I think, a New York Times news article or someone affiliated with a New York publication did an article. And in the article, there were some statements made by the reporter, not Miss Janae, not Ty Tucker, in regards to the case and being weak. And the state prosecuting attorney's office decided to file a motion asking for criminal contempt charges, or for her to be held in criminal contempt, meaning she could be jailed, meaning Tyrone Tucker's bond could have been revoked. And guess what? At the very last moment, Judge Jones loses his will because it's based, at that point, Ty Tucker still had lawyers. At that point, Lauren Janai was going to have a right to come in with her own lawyers, and they were going to have a right to fully challenge and fully vet out the legality of whether or not you can gag a non-party to a criminal case. In the case he relied on, which was a 1988 case, which dealt with the sheriff's office officials and dealt with individuals in the prosecutor's office, not a non-party individual who isn't charged, who is no different than myself or anyone else out here who just is simply asking questions. He violated her First Amendment rights, and he knows that. And the way we know he knows that is because go back and watch the tape. Go back and watch the tape of why he says there's constitutional issues in this case with this gag order, and I don't want to rush and jump into something and cause a problem when people out here are asking questions. And the questions he didn't want to have asked was the constitutionality. And I will answer that question for Judge Jones and for anyone out there. The constitutionality of that is it's unconstitutional. They violated their First Amendment rights, and he said no, they didn't. He didn't want that challenged. He knew that was going to come out, and he knew people were going to look, and he knew now that people were paying attention, that Lauren Janai was already talking to Vinnie Politan in Court TV. He knew that people with law degrees and people that could look at these things would immediately pay attention when they couldn't talk to Tyrone Tucker after a mistrial. When after a mistrial where the state's case was so weak that a pro se defendant gets a mistrial, he knew these questions would be asked, and he knew the gig was up. And then he turns around, and then he recuses himself because he knows what's coming, because he knows that he's the head of this whole thing, because he knows everything ran through him. The cover-up ran through Judge Jones, and that's in the record, and that's supported by the record. And that's what Tyrone Tucker has tried to say on every news broadcast, but they give him 3 minutes, and it's tough to understand. But the way you understand it is the scheme of the gag order. The way you understand it is the way this case grew, and it grew because Penny Phelps believed Tyrone Tucker was the boogeyman. And then what happens is she goes, locks herself in by getting a false confession. Look at the timeline. She gets a false confession when she busts in, guns a-blazing, into the warehouse and pulls Roy Wilson and Tyrone Tucker in. And she strategically lets Tyrone Tucker leave because she believes that's going to make Roy Wilson think that he talked on her. And if you go listen to Roy Wilson and go to Crime Circus, he has a fully edited version that's much easier than what's on Free Franklin Tucker. But if you go on there, you can watch the entirety of that interrogation, and you can see where she is insinuating that Tyrone Tucker turned on him. And you could then, if you then go back to Free Tyrone Tucker, and you see the interrogation room, hot mic, you're here where she's saying we have to get Roy Wilson. We have to go get Rory. We have to bring him in, and we have to turn him on Tyrone because we believe Tyrone is the other guy, and we need him to pinpoint Ty. Because they believe that's what happened. And they believe Ty might have been the one that did the stabbing of Matt Bonnett. So they're thinking that there's going to be DNA evidence on that knife. The problem is the DNA evidence on the knife is one person, Rory Wilson. And on that is Paula's DNA and Matt's DNA, indicating that one person did the stabbing, one person stabbed both of them. And then on top of that, Paula herself, from day one, from moment one, from the emergency room onto the next day in Pitcher's car, onto subsequent visits in Pitcher's car, onto the deposition, and that's what we call corroboration, folks, said left-handed. Roy Wilson, left-handed. Todd O'Quinn says he saw this white guy run out, pull his mask off. 3 days afterwards, he's shown an array. It's Travis Johnson. He says less than 2 hours before, Travis Johnson gets in a truck and drives off. He saw that figure get in the truck and drive off. Paula says from day one, I heard him run down, I heard a car start, and I heard him drive off. We see videotape. Truck comes up and parks. Individual running in the direction of the truck. Only one mask and one knife is found. We know there were two masks, and we know there was at least a knife and another object. Those are never found. The police search everywhere. We know that. You see it. You can go watch the police body-worn cameras. And guess what? Nothing is ever found because there's only one knife and one mask found because that's Roy Wilson's knife and mask because guess what? John Travis Johnson had the other one in his truck. And John Travis Johnson, just as is corroborated by Paula, he took the bag. The bag ends up in his truck, and then it ends up where he was staying prior to getting arrested in an air-conditioned vent. Further corroboration that the second person takes the bag, the second person that ends up with the bag in an air-conditioned vent is John Travis Johnson. Boom. And the only DNA that ends up being tested in this case is the mask that Rory Wilson wore and the knife that Rory Wilson used, which has the blood of both victims that he stabbed. End of story, end of case. And the thing is, Tyrone Tucker never shows up in a DNA profile. He never shows up he is the most mysterious man. He's a man that operates apparently immune to video cameras. Video cameras can't record him. Yet jurors in that juror room thought that they saw and could see out of a little blurb that they thought that looked like his gate. If you look at that, it looks like, if that so much looks like his gate in there, then why in the world did Penny Phelps believe that person matched the walk of the person in the Keys Electric video who turned out to be John Travis Johnson, which means that John Travis Johnson walked a lot like Tyrone Tucker. Completely destroying any of this idea. And I've seen it pop up in comments. And I don't know if that maybe is something that Key West Police Department is putting out there, sending people out. But the bottom line is that there is no evidence at all that Tyrone Tucker did any of this or was anywhere near these crimes or was anywhere near anywhere except sleeping off some fireball shots that he took, and that he was up sleeping off, fireball shots. Give me a moment. Apologize for the interruption there. And that's it. And that's what it's always been. And everyone says, well, where's the evidence? Why couldn't they corroborate his alibi? Well, the reason why is because he had an alibi to be corroborated, and that was going to be corroborated on Tom Thumb, okay? And on the Tom Thumb tape. And the Tom Thumb tape, which he told them to get, he said, get the tapes from Tom Thumb. Todd O'Quinn said, get the tapes from CVS. You're going to see who this is. As is established, which Tyrone Tucker was trying to get in, and he didn't really have the chance to get everything in lined up to get these things in, it's established in the IA investigation that these tapes were destroyed, or in the case of the Tom Thumb video, they claim they got the wrong day. Now, there is a case. At least it's a West Virginia-based case, but I'm certain that there would be cases in Florida. And where it clearly states that, and in fact, this came up in this actually came up in a case I covered In fact, they were citing the West Virginia case in this. It was a Kentucky case. So I know the same thing is going to apply down in Florida. But the idea is this: if the police lose evidence, then because due to the presumption of innocence, the Supreme Court has held, and the West Virginia Supreme Court has held this, and other courts have held this as well, that due to the presumption of innocence, you must presume that the evidence that was lost would have been favorable in the most favorable light to the defendant. So in the fact that the Tom Thumb case or the Tom Thumb video is missing, unlike what Mr. Mansfeld and Mr. Alvarez would allow you to believe, especially with how they attempted to portray the DNA evidence, the fact that it's missing, the fact that it would have potentially given Tyrone Tucker an alibi and that the police had an opportunity to get it, and due to the police's negligence or misconduct, whichever, that it is not available to the jury, that fact, and again, this is something that Tyrone Tucker needs to work with his attorneys on to get before, because that can be presented to the jury, the fact that evidence is missing, and the jury should then, there should be an instruction that can be given to the jury that says that the jury must assume that evidence would have been in the most favorable light to the defendant. In other words, if the defendant is alleging that he would have been shown on that tape and that tape now is missing, and that tape is missing due to the actions or inactions of the police officers who knew about the existence of that tape, then the jury would be able to then assume that information would have been exculpatory evidence. In other words, it would have exonerated Mr. Tucker. So therefore, the jury then would be left with the idea that yes, there was corroboration of his alibi, but the police lost it. That there was evidence that proves it was not him running, i.e., the CVS tapes. That's just why it's very important that he address these issues at pretrial before he gets there with the help of his legal counsel, because the fact that they lost that evidence, and I cannot remember off the top of my head the case. There's a specific case my dad has used it multiple times, and it's a case that is used. Like I said, it was also used in the Bryce. What the heck is his name? I covered the case. Bryce is his first name, and he's considered to be America's worst defendant. And it was used in that case because they lost a couch in that case. And so when you apply all of that, the lost evidence, you apply the lack of DNA, there is no path to conviction here. And hopefully that gets laid out in the motion to dismiss. But I also hope that they also put forth evidence to the jury, and that they're allowed to, and they have to bring forth the testimony that shows that they had it. And the only person that's going to be able to do that will be Detective Malone, which Detective Malone threw off and said she wasn't responsible for the Tom Thumb stuff, I believe. And then they need to also get in whoever the detectives were, whoever it was that was responsible for getting these tapes, and say that yes, they were available. And I do believe Detective Pitcher had some missing footage that got deleted. So, it would behoove Mr. Tucker to try to get Mr. Pitcher, if he can, into this case. It would behoove him even to get Miss Phelps into this case, because you need to show the jury what she did and how she conducted herself and how she assumed that it was Tyrone Tucker. And then she did everything in her power to try to get Rory Wilson, get April Walker, get these witnesses to go after. And it was for no other reason than she just genuinely thought that Tyrone Tucker was the guy, because he was at Metro PCS and she saw that photo and she realized that Tyrone Tucker lived down there at the warehouse. And that's who she just thought it was going to be. She looked at him and she says it to April Walker. That was it. Now we're going to end this session here, and like I said, I've got some other things planned, but we're going to end this session with the broadcast that played, and I want you to hear Court TV's take on the judge being disqualified. I think it's very interesting and very telling about how they feel about this. Give me a moment here. All right, and let's play it.
In the treehouse murder trial out of Florida, you may recall, pro se defendant, and it was a hung jury. He's expected to be charged again by the state. They already announced that. Well, the judge in that case, who was forced to declare a mistrial in that case against Franklin Ty Tucker, has chosen to recuse himself, rather disqualify himself in Tucker's upcoming retrial. Judge Mark Jones filed a certificate of disqualification last week saying, "I feel that I am disqualified to sit and act as judge in the above entitled cause, and therefore recuse myself from taking jurisdiction of said cause." The trial has now therefore been handed over to a new judge. Now, this all comes, of course, after the jury was not able to reach the verdict and whether or not Ty Tucker is guilty of taking part in a robbery that left one dead and another injured back in 2017. We've also learned there was a surviving victim. It was Tucker's star witness, Paula Belmont, and that was someone he was good friends with. There she is. She passed away earlier this week after having some health conditions. Still with us, constitutional attorney Chris-Ann Hall. Chris-Ann, let me ask you about this case, and just tell me, have you ever experienced a case in which the judge themselves says, "I need to be disqualified, I can't hear this next trial"?
Yeah, actually, it's not common, but it does happen.
I want you to hear that. It's not common, but it does happen. This is a rare circumstance, what this judge did here. So we can infer that given all of the crazy circumstances in this case, the fact that, again, this judge put himself at the center, put himself as an individual who was doing in-camera review of all evidence, all discovery, and he was making decisions to gag, and then not only just gag the participants and keep people from talking at a time when the press was heightened interest, and it worked very well, because this case went to trial and those national news medias left and they didn't ask any more questions. But then he starts sealing all the evidence. He seals the notebooks of Penny Phelps. He seals her testimony. We don't know what her testimony was. There is a deposition of Penny Phelps taken that we have no idea what it was. There's still evidence. There's discovery. If you go in, you will see sealed discovery files that are still sealed today that we can't see. The public can't see because the state asked that they be sealed. And the state had to make a request within 90 days. Basically, the way this worked is within 90 days, they had to make a request to either let it be unsealed or seal it. In the state, if you go in, you will see various requests where this state's attorney's office, and it wasn't just Mansfield and Alvarez, they're the ones who ended up with this turd of a case later on. So they were not complicit all throughout this, but they're complicit for getting a hold of it now and being the guys to go stand up on behalf of the state. But Dennis Ward, the district attorney, the head man, the head honcho, he's the guy who was allowing this to continue. He is the guy who could have intervened at any point. He's the guy who authorized the 2-year deal. He's the guy who has encouraged his prosecutors to try to keep Tyrone Tucker locked up like a prisoner in his house, trying to get him to take a plea and push all of this under the rug. And he's the guy that, is the one that now is having to protect his own petard because he knows this is blowing up on him. And here it is. Court TV right now has just told you, this legal representative, not me, not a legal person, I'm not a legal expert, but this individual, she said, this is not common. Let's listen further.
It's a bit strange at this point, but nonetheless,
it's a bit strange.
Judges have to recuse themselves for various reasons, and it's why it's an important option for a judge to maintain the integrity of the justice system. I think it's of the highest integrity for a judge to say, hey, there's a reason why I cannot sit on this case. I am conflicted on this case, and it is my desire, it is my devotion to have a fair trial, and to do that, I can't be the judge.
Yeah, I agree with you. It does happen. We're going to talk about it.
All right, so I want you to understand what this representative just said. What he said in that motion, he did not give any reasons. He was conflicted, and he doesn't have the ability to sit anymore as a fair judge on this case. So the question is, why is that? We have to ask the question. Why is that? What's he afraid of? Is he saying, I don't think this case should go to trial anymore, and I'm not going to be able to sit here and sit on this, but I don't want to be the one to say it? because then all these questions are coming at me? Is he saying take the spotlight off me because when these questions get asked, when people are coming, because we've put Judge Jones up, we've seen how Judge Jones treated Mr. Tucker. We know Judge Jones was responsible, could have dismissed this case in July of last year and chose not to. Is he running away because he knows the illegality? He's a guy who expressed the last words in open court was him expressing whether or not the gag order he had issued years before, which he claimed was very involved, and it's really not when you read it. The constitutionality of that gag order, was it really that involved? Is it that involved? No. But the only constitutional issue in that gag order was the fact that he chose to gag a U.S. citizen who was not a party to the case. He chose to violate her First Amendment rights, Mrs. Lauren Janae, and he chose to gag her. And he knows. And then not only that, he did at least have the sense to not hold her in criminal contempt and lock her up, because he knew her high-powered legal team was going to be coming. And he said the distraction and the issues it would pose, he knew that would be, he wanted to, well, I don't know. That, I think, like I said, this is going to be a very big opportunity for this judge to send the message in this case. Either we're going to find out that this judge has been brought in for purposes of continuing this charade of a case, that he's been brought in because now they want to, there's two reasons why he was brought in my opinion. One of them being he's a fair guy. Judge Jones said, listen, I don't want nothing to do with this. And they figured the only way we're going to extricate ourselves is get a guy in here who can do a review of this case. And this guy's not related. He's a new judge, and he's not going to have any problems with anybody. He won't be beholden to anybody. And he's the guy that can issue the order to kill this case. Or B, they want to bring a guy in because, remember, Mansfeld said, Mr. Tucker, you believe this is a result of the Bubba system, right? The Bubba's coming after you. So the other option is, again, this is a new guy. He's a public defender. He's the perfect guy that they can bring in, and they believe he will add further credibility because he can say, I'm fresh, I'm new, I wasn't around during all of this. And if he were to put motions forward and push this forward, right, and continue to push this forward, they would believe he would have more credibility to allow them to say, see, Bubba's not coming after you now. We put a new judge in who had no ideas, and he's finding all the same things that Judge Jones found. So we don't know what they're trying to do. Now, if they are trying to do the second option, right, the key here is we have to be watching. We have to be ready. We have to be ready to make sure information gets out there, and we will know if he slams down another motion, if he slams down the motion to dismiss. Well, exactly. They were, Dennis Ward was saying that because he was embarrassed, because he was worried that he was losing credibility because remember, Court TV and everyone, all the legal commentators called him out because there's another clip that can be played from Court TV where Court TV asked questions and they said, oh, why in the world would you, go forward with prosecuting a case without even taking a second to hesitate? And he claimed, well, the reason why is it's 11-1. We were one jury short, so there was nothing to. But 8-4 is far different from that. If you're at 8-4, you're at 9-3. You've got 3-4 people in the room that didn't think your case was good enough. You should take some time to reconsider your evidence, take a look at things, and go forward. So they didn't want that storyline getting out there. They didn't want the idea. Look, 8-4 with a pro se defendant who's never tried a case, who clearly didn't understand the rules of evidence, who again, his story gets even better when you consider the fact that he literally, remember, he filed his motions in September and October. He had just become pro se. He wasn't prepared for trial. Okay, that trial was more likely than not, if he would have agreed to it, it would have been continued. But they set him up. And he said, I rolled into Key West believing that JoJo, John Travis Johnson, wasn't going to be showing up. He wasn't going to be showing up. He was in the wind. And then it turns out, oh, he's not in the wind. It turns out he's right there waiting to testify. And as a result, they get the opportunity to go after an unprepared an unprepared pro se defendant who didn't even have his subpoenas in effect until what was it, 4 or 5 days before trial or something like that. I mean, if you go look at when the subpoenas got issued, he was completely on the seat of his pants, And his attorney said, get in there because you can get in there and do this and you can end the case. That's why he showed up. And the thing is, if he would have had his attorneys, the trial would have never taken place in January. It would have gotten pushed. But the problem is he just got his attorneys out, and his original reasoning for this was because he wanted to be able to file his motion in limine and include information in it that he knew his attorneys wouldn't be allowed to include because they would have known better and they could have been sanctioned by the state bar. So he filed the motion in limine, got that in, and it wasn't clear if he was going to go forward or not without lawyers. And then he decided to go forward. And then, of course, they got wind. His advisors, who were his lawyers, are still there. They're just acting as advisors right now. And they said, hey, we got wind. This is what's going on. This is the word on the street. And the state leaked that or put that in effect, as they've done with many other aspects, but it turned out to be untrue. So Tucker walked in there thinking that he was going to, they were going to call the case to trial. They thought they were pulling a fast one on the state. State was pulling a fast one on them and had JoJo John Tucker all the time. He was not there. All right, so let's finish watching
a little bit more. Thank you, of course, Chris Ann Hall, for joining me on both of those cases. But on Tucker, before we go, I do also want to share today's thought from the bench. In Florida, a party can ask that a judge be disqualified for a few different reasons. For instance, if the party believes he or she will not receive a fair trial because that judge is prejudiced or biased, or if the judge is related to one of the attorneys, if the judge is a material witness in the case. These are all reasons why a party can say, please, judge needs to be disqualified. But the unique part here is that the judge himself asked to be disqualified, not recused. Those are two different things. He didn't say, I need to be recused because of this. They wanted to be disqualified. And a judge should disqualify themselves for any of those above reasons. The disqualification is really vital to safeguard and ensure judicial neutrality. While we don't know the exact reasons behind the judge's request to be disqualified, I sure do respect that he made a decision that he made was in the best interest of justice. Call a spade a spade. That's exactly what he did. Good for him.
So I don't quite read it like that, but as you can see, there are reasons why a judge, and as she went over all of those very good reasons, every one of those makes it all the more suspicious that he got out of this case without giving a reason, without understanding why. And you heard it right from legal scholars and experts who said this is very, very unusual. Everything about this case is very, very unusual. But the important thing is that we have to make sure that we are watching, that we're keeping our eyes on this case, because you have to anticipate that either that there's going to be something else that the state's going to try to do here. Either that, because there's really no other way. Unfortunately, what's happened here is the state has been backed in a corner, and the only thing they can do, it's kind of like, when someone's lying and somebody's got you on words, what's the first thing they're going to do? What's the only thing they do? They punch you in the mouth, and they hope that when they punch you in the mouth, you back off. And that's what they're doing to Mr. Tucker. They're punching him in the mouth, and they're punching him in the mouth again, and they're punching him in the mouth again, and they're punching him in the mouth until they hope that he takes a plea or he walks away, and they're just hoping that he doesn't fight back and win. And that's all they can do. Why did he? Well, that's the thing. We don't know. He didn't say why he disqualified himself. We have no idea. Remember, Mr. Tucker had indicated he was going to file a motion to disqualify, but that wasn't filed yet. So it's very interesting. But I think that when you watch, and again, I think when if you rewatch, and again, I think maybe that would be pertinent to do that as well. If you rewatch the judge himself and how he was acting when the mistrial was declared, I think that itself speaks volumes and kind of dictates that something was amiss here. So let's hold on a second here. courtesy of Law and Crime here, we'll take a look at this, and then we're, as one of our final things. I know I said that before already, but I think it's pertinent to watch that and understand, in the light that we see, everything looks different once you have better contacts. So, courtesy of Law and Crime, we'll watch this clip.
And yes, there has been plenty of media coverage, and I don't see how we're going to roll back and unring the bell at this point. So I don't see the point at this point. I just don't see the point.
Yeah, I mean, I got to tell you, that seems to me to be something that's going to take some thought.
And he's talking about the gag order.
Got to refresh my recollection as to the extent of that and what that would mean. So that means that.
Right, Judge, the people, we were not allowed to talk about the case to the media, did interviews about, the defendant was posting on Facebook all day today, even during closing arguments. So, how are we ever going to get a jury here in 2 months that hasn't heard something about this case and is taking this jury pool?
Your Honor, if I might, I somehow doubt the rule.
Let's relax. Let everybody just relax, okay? Let's just. I know it's been a long 3 weeks, but now's not the time to get too argumentative.
And you can see the judge is very uncomfortable right now, because he knows what he did in that gag order, and he knows now there's a lot of attention.
Asking myself the
Right here, watch, listen to this.
And the enforcement of it, and I
understand, Judge. Let me just put on the record. Last night I received about 11 threats on my phone, on my personal cell phone. They started yesterday afternoon. They continued into the evening. I don't know how my cell phone number got out there. I suspect how it got out there. But now I'm receiving death threats to the phone. I'm going to have to change my phone number. This is what I'm talking about. This kind of media blitz is affecting me personally, and I don't think it's right. So I've been changing my phone number because somehow my phone number has been compromised, and I got threats against myself and my family.
Mr. Tucker, please.
And that's when Mr. Alvarez is speaking, Mr. Tucker gets accused. You can see the judge is totally befuddled.
Raised a legitimate concern. I'll give you a chance to respond. So that's very troubling. I certainly am disturbed by that fact. I've received in my office, which I've endeavored not to read the emails or ask my assistant not to, tell me what these phone calls are about. I'm not aware of any threats, but I'm certainly aware of people's criticisms and comments and opinions. That's a natural product of the coverage this case has received, and so all I'm asking myself, and I'll confess, I don't know that I have my head wrapped around the issue right now. I remember the order that I issued. I reviewed it at the beginning of the case when I suspended it, and it was pretty involved, and I would think I'm almost inviting problems.
Right here.
All of a sudden, I say, oh, it's in effect, and all these people are curious and the like start talking and asking questions, and I don't want to have anybody in a gotcha situation. So certainly, I think rules and ethics and laws would certainly say that there should be no communicating threats, no intentional rabble rousing, so to speak. I don't know what, or
All right, so let's take a look. You know what? I'm going to show it. We're going to take a look. I have the original gag order right here. Let's take a look at it, and I'll show you, because it's fresh off of what the judge said. It was so involved. It's so crazy that it requires him to do all of this reviewing of it and the constitutionality of it. Hey, let's decide. You decide for yourself. I'm going to show it to you. We're going to do it right here, and I'm going to be doing a more involved review of this. But here it is. It's actually a pretty simple document. this cause having come before the court. Hold on a second here. Wait a minute. I got the wrong document here. Give me a second here. Hold on. I picked up the wrong one. I picked up a screenshot of it, but I hope I have it down here. Original. Oh my. Maybe I have to go back down. I guess I thought I had downloaded it, but I've got to. It's not going to be an easy one to find either. But okay, so it's a 5-page document. But I'm going to have to go in and do, like I said, I'm going to be doing a bigger video on the gag order. But unfortunately, I only had a screen grab there, so I thought I had it ready to go. But I guess it just screenshotted it. I didn't actually download it and save it. But in essence, the main portion, it just stated, as I said, it stated that the parties were not able to talk, and that Tyrone Tucker was not able to make statements. His attorneys were not able to make statements. The prosecutors were not able to make statements. Police, witnesses, etc. And then it also sealed all evidence that was put on record, all discovery that would be filed, which normally under sunshine laws in Florida would have gone and become available right on the clerk site, and any press organization would have been able to request it. And they knew there was extreme interest that these things would have happened. And as a result, it shut down documentaries, it shut down news reports, it shut down coverage. And then on top of that, he went the extreme extra step to gagging Lauren Janae. And as a result, that's the part that gives him hesitation, because that ended up being subject to a lot of litigation in the case. And as a result, that's why he was sitting in that courtroom, I believe, hemming and hawing and not wanting to just institute it back in effect, because he knew people were going to come in, and if that was a source of huge contention, that was a result of various different motions to have that gag order dropped and reconfigured, and to have that portion at least removed. But they didn't even want her talking, because they knew that she was somebody who was trying to put the truth out there. She was putting the documents together. She was putting discovery out. She was putting things out that were absolutely allowed. And then they sealed all of it, and they kept it from going forward. And she couldn't release it, and Tyrone couldn't release it. And now basically they couldn't speak to anybody. And as a result, it worked, because all attention to this case just dropped. And it didn't pick up again until he shows up in court as a pro se defendant. And yes, I would agree with you. I think Court TV is absolutely, their interest has absolutely got that judge scared. Law and crimes coverage of it got that judge scared. I think that the coverage is something that, again, everybody watching and everybody asking questions and making sure that they're aware that we are watching. Like I said, they were watching. You heard that state attorney. They're watching his Facebook. Go put your comments on his Facebook page in support of him. If you want a supportive comment, that you support him being his motion, that you support whatever you see happening in court, because they're watching and they're looking. And the new judge will be too. It's important that go get subscribed at Free Franklin Tucker. We need to get as many people over there subscribed as possible. We will consider every subscription. I would imagine I would at least consider a subscription a voice of support. But the more people that subscribe over there, the more it becomes clear that there are eyes on this situation, and that they are not going to get away with it. That they are not going to get away with it. Like I said, I'm going to be profiling the entire gag order, how it originated, when it originated. We're going to get into it. I've got a video planned. I'm glad I discovered there that I guess I didn't scoop up the gag order like I thought. I'd read it, but I somehow screenshotted it. I don't know how even that happened, but whatever I was doing, I didn't do it right, I guess. But I'm going to go on and get it, because that's a very important document. That gag order is extremely important. And if you want to do your part, download documents while you can, because we can't trust that anything will be done correctly or honestly in this case. It just will not be trusted that will happen. So, guys, I'll keep you abreast. I'm going to keep watching because there is a motion to dismiss that's going to be filed either sometime this week or early next week. And when that comes out, rest assured I'll have it up and we will be breaking that down and going through it. As soon as it hits, I'm watching the Monroe County docket, and when it pops, I'm going to download it and we're going to go through it, and we're going to cover it because it's important that they know people are watching, that they know that it's not being unnoticed, and that this judge understands that he needs to look at this case fairly. We're not asking you to do anything unfair. We're asking you to simply look at the case fairly. That's it. With that said, guys, appreciate you watching. Appreciate you tuning in. If you're watching this on a replay, check out my latest videos on Tyrone Tucker. It will give you more light. Especially check out the one that goes into showing the videotape of Todd O'Quinn talking about the car. Check out my latest shorts. I put together some other information that'll be coming out as well. I found some further corroboration of what Todd O'Quinn said. And check it all out, guys, because there's only one conclusion you're going to come to. And that's that he's innocent. And I gave you the entirety of it. I answered every question that's been posed in my comments. The whys, the hows. And if you don't believe me, I'm challenging you. I would never expect you to believe me. And I would never expect just because I cut a video and put it on here that you believe me. I'm challenging you. Go in, prove me wrong. Go to the Monroe County clerk of court. Download the documents for yourself. Give them a read. Go to freefranklintucker.com or YouTube channel at Free Franklin Tucker. Watch the videos for yourself. Check them out. You're going to see my comments on them. You're going to see areas. You're going to see things. You're going to see other people's comments on them. Go check them out. Go watch them for yourself. And then go tell me what you conclude. Come back and comment. Come back and tell me. Come back when I'm live. Because I will say, your comments have helped a tremendous amount as I put these videos out, helping me look at things and see things and go back and rewatch this and watch that. And I guarantee you it's helping Mr. Tucker because he's watching. I know that his attorneys, I'm sure, are watching to some extent. They're watching what you are saying, and it's extremely helpful to see what the public is, because the bottom line is you, me, and everyone else out here, we're all jurors. We're all potential jurors. So it's important to see how this stuff lands. It's important to understand when we see something, what more did we need? What questions does it bring in our minds? What questions would we not have thought of, or would he not think of when he put something before you? And that's what's important to me as I've been asking questions myself and going through the questions of others. Anyways, guys, with that said, I appreciate you guys watching. Until we talk again, let justice prevail, and I will talk to you soon.